to take it
It's
easy out.
helpful to see it.
Yeah,
I've had to look at these so many times.
Or it's funny, or it's like, they're in a triathlon.
Mhm.
one other,
Matt.
Matt, yeah, waiting for one other committee member, and I
You don't
don't
need
see
everyone
him
for
yet.
it, you just need
So-
at least 3 or more.
Yeah, we need a quorum.
I think we have a quorum, yeah, I think we have,
Good.
'cause,
3 or more. You're good.
yeah, so we can, yeah, thank you, yeah. So. Yeah, Terry, if you,
We're ready.
we're ready, okay. So, good evening, let's see, this is the March 6th, policy committee meeting for, MSAD11. My name is Tony V. I am the policy committee chair, and I'll have, I guess we'll just do introductions for committee members. Joanne,
Joanne O'Brien.
Yeah.
Molly Rogers.
Tony V, and then we have board members.
Michelle Tucker.
Yep.
Sage Scully.
Thanks.
And Angela Hardy, Director of Curriculum, in place of Pat Hopkins, Superintendent tonight.
All right, so we have a number of policies that, let's see, we had visited sort of recently, actually. Several of these went through back in September. Yeah, so we've seen all of most of these recently. There's been a recent executive order from at the federal level to have our current Title IX policies comply with 2020 Title IX regulations. And so that's what this process is. The agenda listed as walking back those policies. So we're going to be looking at those. There's several that are there for rescission. Those are not included in here, so we won't see them for rescission. Several of them have a correlate to the 2020 Title IX regulations. Angela, is there anything more we can add about while we're revisiting?
It's the same, I mean, it's because of the executive order, and in Maine, that means the policies that you have adjusted reflect the 2020 Title IX guidance, mirror the 2020 policy versions provided by Maine School Management, and also do still align with the Maine Human Rights Act, which is required in Maine.
Yeah, thank you. So we're kind of walking with both of those. So we've got those that are listed as the walk back on the agenda, and then we have the policy review, which are, and excuse me, I have a lozenge. We also have the other policies for review as we go through this. So I'll jump in. Actually, I'm noticing one thing that jumped out as we went back to file AC. So on the first page, the 1, 2, 3, the fourth paragraph, that last line talks about braids, twists, and locks, and we see the spelling LOCKS. We also see another spelling later in these policies, LOCS. And my understanding is that the correct spelling would be LOCS. So I would recommend that change. Still pronounced locks, but yeah.
Yeah.
Locks to locks. Yeah. And yeah, and so I'm good on AC. And yeah, nothing further on AC than ACAA, which is harassment and sexual harassment of students. Same adjustment from the second paragraph, braids, twists, and locks, LOCKS to, I would recommend the change LOCS.
Change noted.
Thank you.
Are we discussing any of the policy itself or?
Well, what are you noticing?
Well, page 12 of 14, under discipline and other actions for students under the AC.
We're only on AC right now.
Oh, okay.
And then
Yeah,
ACAA.
I do want to get there.
Okay.
And I anticipate we will, but yeah, we can just, go through these. And I did a comparison there. They seem, there were the adjustments we made back in the fall. We're just going back to right before that. These seem, fairly similar, and talk about the concerns that people would look for, what, defining what sexual harassment is. So in this policy, right? And that part seemed fairly consistent with what we have had as well. Let's see, I feel like we're moving through these quickly, but we've been through them
Right.
pretty recently. Actually, it just has this very recent memory kind of feeling to it. Moving on from ACAA, we are moving to ACAA-R, which is the complaint procedure for student discrimination and harassment and Title IX sexual harassment complaint procedures.
First thing for me with the actual name of the policy wants to be highlighted.
Oh, yep.
The first line of the document.
Yep. Thank you. Contact information still the same.
Yep,
Definitions,
it is.
right? Yeah.
Yeah, so you go first.
Okay.
Yeah.
So my question, page 8, section C, emergency removal or administrative leave.
Let's see.
So it's just kind of a technicality question, but it's the superintendent may remove a student. But up to that point in the policy, the complaint wasn't made to the superintendent, or like, how does the communication make it from the Title IX coordinator to the superintendent in that situation? Is there a, like, do we have to explain that path or identify that path? There are times when it's reported to the Title IX coordinator and or the superintendent, but
Once a formal complaint has been filed, it goes to the superintendent automatically. The superintendent needs to be aware of any formal complaints.
Every time any formal complaint is filed, it goes to the superintendent after me.
After affirmative action officer.
yes.
Right.
As noted on page
Yeah.
1.
Formal complaint would go.
Okay, so it's automatically identified that way then. Okay,
And so, yeah, that section gives the superintendent the authority to move in and say.
appropriately,
yeah.
just
Mhm.
wasn't sure if it was laid out to.
And I guess at some point in time, if it needs to be a permanent removal, then it would come to executive session for an expulsion hearing.
If we're speaking about a student, yes.
Yes.
Or a personnel matter, also executive session.
Is that what you were kind of curious too about?
No.
No, okay.
It always goes through an investigation, and that's what it says under number 2, for if it was an employee.
And then they have the right to, at the very end, if they don't agree, they have a right to, what's the word I'm thinking of?
There's a resolution process and the
Um,
investigation.
No, you say that you don't agree and you want someone else to take a look at it.
Oh, arbitration,
Right.
arbitration, yeah.
That would be for employees, correct?
That would be for each.
Yep.
Each.
They can, yeah. They've identified parties that are appropriate to them.
Right. My next was on page 9 at the bottom in section F under investigation. We identified it.
Sorry, where? Page 9, investigation.
Yeah, at the bottom,
Mhm.
section 1. It's superintendent and the Title IX coordinator. Is that an absolute, it's both of them? Or is it and or? Do they identify it together?
Jointly, yeah, good.
Affirmative action officer needs to support the investigation and the superintendent needs to maintain an understanding along the way. So oftentimes it's done in coordination or with one another, even if the affirmative action officer is the primary investigator.
Okay, yeah.
A lot of times it'll be like a principal that helps with the investigation. But the superintendent is always involved at the end, if it's formal.
Right, it's just saying that this person is designated by the superintendent and the coordinator, so you're both designating the person together.
Yeah, like the
Some-
principal.
Some
or-
schools have a different coordinator, like a Title IX coordinator and different affirmative action officer.
Right.
We have the same person.
Right. I'm just saying that both people have to be in the room making the decision together.
Mhm.
Good. Check it.
Mm.
Yeah.
Sort of, yeah, actually sort of implies, right, as they're designated, if it is happening, that the designee superintendent and affirmative action officer should be included on like an email, right?
Yes, most often it's
And
done in
I imagine
person
it would,
Right.
yeah.
rather than email.
Yeah, good.
Do we get to page 12?
Yeah. I think page 12.
Under discipline and other actions for students. I would like to add a written warning as the first step, before in and out of school suspension, expulsion, restorative justice.
Did I just hear you say you have to give somebody a written warning before you give them?
No, I'm just saying that that should be in something that is a first step, that there's a written warning so that everybody is informed about this is unacceptable behavior.
What if it is an extreme case?
Oh, I think then you still write up the whole thing and move on to the.
Well, the investigation is written. It becomes there's a complaint and then there's a determination of an investigation. Then the investigation is fully documented, which point the person making the complaint and the person a recipient of the complaint are well aware that there's an investigation undergoing.
I'm thinking about things that are a little bit more seemingly innocuous, but need to be addressed formally. And that, if someone calls another child a slur or whatever, that there needs to be a written documentation, even though there's not a big investigation moving towards an in-school suspension or any other particular disciplinary thing, but that it's on file, that this person has been notified that this is against policy, it's against educational law to be calling people various slurs. And we just have it on record that we can get a report about how many times this happens.
So we do that as
Yeah.
part of our behavior incident reporting mandate that we have, and it's internal and through a documented process.
I think it might be
This one is
contained in the cross-
specifically involving sexual harassment. These options, these discipline options are one or more violations involving sexual harassment. So I just want to make sure we're clear that like if it's a statement of a slur, that's in a different section. This one is specifically
Well,
discipline
if-
involving
if-
sexual
If
harassment.
you were accused of sexual harassment, you would get a letter at the end of the investigation. And if you were found innocent, it might include, which it has before, that you were found innocent, however, your behavior was inappropriate. Moving forward, you need, those things can be in there. And so
Okay.
I think I know what you're saying. And we do give some of those, but a sexual harassment investigation is very different than a harassment investigation.
Okay, but we were
Can I
talking
point
about
out,
dreadlocks and
Sorry.
stuff.
that was in
earlier.
an earlier
That's a different policy.
Different policy. The findings and subsequent actions actually says that it's
Number
done in
6.
writing. Like, I don't know, is that not?
Yeah,
Because we don't have to like determine what remedial action,
Yep, yeah.
it's on page 5.
and it also,
Inform the complainant and respondent in writing of the results and its resolution.
and the determination of responsibility is also conducted in writing.
Okay.
So there's a written process almost along each step of the way, as Terry was sort of trying to describe.
Let's see. Oh, I'm pretty sure, sorry, just looking at the cross-references, the cross-reference policies for hazing and bullying. Those, I'd have to look at them a little more closely to say that there's written components in there, but I know when we've had expulsion hearings, the list of infractions come up. So there's documentation along the way prior to getting to this level of investigation, which Terry, I'm hearing you say, when it rises to this level, this is a very formal level, that notifications have already,
Right, they're going to go
they're
out.
going out and it's in motion.
Usually, especially if it's usually what happens is a letter goes to the child and and it's written in a little bit different format. And then the letter goes to the parent that's written more formal.
Or,
If they're found guilty, or if they're found non-guilty usually. Unless it's really something very small.
okay, well, we had a discussion about like a particular situation.
Mhm.
Would a child be, and the parent be notified in writing?
It would depend on the circumstances.
Okay, and that's what I'm saying, if, as in the discussion that we had, I would think that
That's
something formal in writing to the student saying, you're being notified that saying this to another person
Inappropriate.
is inappropriate, it's unacceptable, we don't do this here. It doesn't have to be a big thing, but I do think that if children aren't told that certain things are unacceptable, that we don't allow this here, they may get the impression, depending on various circumstances, that it's not a big deal. And then when they get out into the real world, in a bigger situation where there's more diversity, then it could be a big problem.
Joanne, I hear what you're saying. I hear including that written piece. I think with the investigation level that we're talking about, it's a very formal process with notification. And earlier warnings, if there were earlier warnings of behavior, that would be captured again through policy at the administrative, either, classroom or probably building level. So those notifications would have gone out, that the student would have had warnings unless it was so egregious and immediately jumped to the harassment level, which again, the investigation, and I think we've used it, Terry, you've used it. I think it's worked. I think the policy lays out the investigation process pretty clearly, that's my impression. So I'm hesitant to make changes as recommended, because these come vetted from MSMA.
And
Legal
in
staff.
this particular
attorneys.
policy, the written note for this particular policy, for this instance, and this is a procedural policy,
Oh.
the written notification is already happening in advance of this stage. So once you get to section H, there's already been written notification and determination either way, and that's been in writing. And then this step is, if it's a violation, they've already been told that there's been a violation. If it wasn't a violation, they were told it was a violation in writing. And so then what are the options for discipline after the written part? So the written part precedes letter H. Now we're at letter H and it says, so what are the options that the superintendent can access? as discipline towards a guilty violation.
It might help that, we're missing the word examples in the first line under number 2, the following are of the types of discipline. Well, because it's exhausted, right? I think I don't know if, do you know whether it's an exhaust, like, is this the list of options, period? Or?
These are the typical
Right.
options. If it was something like expulsion, it would come to the board and the board would have considerations in which
I'm
you
not
make a
even
plan.
Talking about anything that's that.
Right, what you're
Egregious.
asking for is written documentation that the action was inappropriate, and though that happens multiple times before we get to stage H in the procedure. So rest assured, they're getting written documentation that if the act was conducted, it was inappropriate, and here are the steps to take. And this policy, procedural policy, assures you that's happening. It's just not written in section H because it's already happened in sections A through I.
Actually, as we look at I-6 on just above on the same page, the written determination shall be provided to the parties simultaneously. That's the finding of the investigation, but there's a written component right there. But the extensiveness of the investigation is I think it's detailed pretty well in E through the informal resolution process and then F through the investigation.
And are you allowed to respond to sexual harassment with a written warning? If it's found in sexual harassment?
No. If the investigation concludes there's a violation,
Right.
no.
But then under the,
And I
Just
think that's what
under
this is.
employees, it has written warning.
Yeah, I see that.
That was my big confusion. For under employees, it was written warning.
Mhm.
But I'm assuming that if there was an investigation, that would have already also happened.
But it's saying, I guess, you do it again.
I don't know how it feels that way. Well, you have written warnings for the adults at that point where you've already determined that if there's a violation. I mean, unless you had the written warning that if it happened again, there was the possibility of.
And often, if it's a written warning and through the investigation, they've already been out on administrative paid leave. It may be determined that the written warning plus that prior leave was sufficient, depending on the circumstances.
No,
Which is why a
I'm
written warning
talking-
might be acceptable for an adult under these circumstances.
It looks like, yeah,
Depends on the situation.
there's different actions for employees versus students.
Well, there would be because
Yeah.
there wouldn't be demotion, or suspension without pay. But the thing is that if before the in or out of school suspension, if there was a written warning that if something were to happen again, then there might be an in-school suspension, or there might be, like in hazing incidents, you could be benched on a team, or you were not able to be in extracurriculars for a period of time, or some other thing. But you start off with the written warning saying, okay, you were found guilty of this thing. We just need to lay out that if this happens again, that the consequences are going to escalate. You can understand one time, someone says something and they may not even know what it means, or that it was very offensive. But then you just say, okay, we've handled that situation. You're found guilty of it. You did say it. But in the future, if you do it again, then it could be a case for we'd have to do something more.
I have to be honest, I give a lot of talks. I give a lot of educational talks about these things.
Mhm.
And especially when a really little kid does something, to write them up is really hard because they're learning. And so as you get older, writing somebody up, I think would be a little bit more appropriate. But especially when they're really young, I usually use it as a teaching moment, but the parent always gets a phone call. And sometimes a parent meeting. And that makes a big, instead of getting a letter in the mail, the phone call or the parent meeting makes the biggest difference.
I would say for elementary school, I would agree with that. Once we're getting into middle school and high school, I
Much
think,
more written.
I think it's a different situation.
More
And,
written.
and it could be done age appropriately. It doesn't have to be
Are you talking in response to filing a formal complaint?
like, if a
Because not
parent,
just like
Yeah.
identifying, but filing a formal complaint,
if
the result.
a parent sends a letter to, the principal and to Terry, saying this happened and I'm really concerned because this, I don't know if this kid is aware of what they said or how offensive it was. And I don't know if it's being done to other children, but I think this needs to be addressed. Okay, and we find out either through witnesses or for the kid themselves that, oh yes, I did say it. Maybe they didn't understand what it was. So we have to talk, right? And then we say, maybe a written note home to the parent saying that, you know, your child understands that this is now unacceptable. But please be aware, if it happens again, we're going to have to take further action.
So to me, that feels like that's actually letter G, number 6. There's a written determination and it's provided to all parties simultaneously. The determination concerning responsibility becomes final unless there's an appeal, basically. So it's stated there will absolutely be written determination either way. There will be a conclusion, it's documented, and it goes to all parties involved. Which is what it seems like you're asking for.
Well,
Is it just because it's specified for the employees?
And all parties are getting that before we go further down. And then it says remedies may include supportive measures and may include other appropriate measures depending on the determination and the needs of the complainant.
I'm also trying to differentiate between, I mean, as a parent, I've reached out to the teacher and said, is this going on? Can this be addressed? I don't think that has been interpreted as me filing a formal complaint.
right.
And so
because that
that's
would
where it's
be-
handled, and this is only talking about remedies to formal complaints.
Generally speaking, though, kids that get bullied,
But this isn't bullying. This
Right.
is discrimination and
Sexual
harassment.
harassment.
Then we have a separate bullying policy.
So I think what you're saying is appropriate when, you know, there should be a written response and all of that, but I don't think it's triggering this policy.
well, in the case of someone calling a young boy a particular name
Okay.
based on perceived
And this one's sexual harassment, right?
sexual perceived sexual orientation. And gets other children to call that same boy, that same name based on perceived sexual orientation. Okay, if this is an ongoing thing,
An investigation will be conducted
Right.
following this procedure.
but it's not just a case of, you know, you contact a teacher, you need to file a complaint, no?
Yes.
So, but a
Right,
complaint
this
then
lays out-
results in an investigation results in a report, a final report. The final report is a written document that's sent to all parties. So you're asking for an additional letter on top of that.
I would say if there was a letter of warning for the first time around.
Before it was filed as a complaint.
Yeah,
I think
I,
it's contained in there though, because yes, the written notice would have been sent out because it determined, at this point, it's a discipline and other actions, right? And you're kind of saying, right, could we do a written warning there? There'd be written notice of the findings of the investigation. In-school suspension is a penalty, but, would have the opportunity for a little bit further down there, the restorative justice piece. The options there to allow for that reflection and still maintain in the building. That's not excluded, but there is a penalty following the finding.
And
I mean, I
so
like the-
are you asking then that if there's a finding of guilt, you're asking under the student section to send a letter of warning rather than as one option, including in or out of school suspension, expulsion, restorative justice,
right.
requirement to engage in education or counseling program. So in lieu of those options, they could
Not-
get a written warning.
If it's a first-time offense and the person really had remorse or didn't understand,
But that's restorative justice. That's the process for restorative justice and then is documented.
well, what is restorative justice? I mean, it defined what that is specifically.
I have a little thoughts on that, but I don't have it in front of me.
Yeah.
It requires, it requires communication with the individual, and an adult. Oftentimes, we then bring in a mental health counselor or social worker in that, depending on the situation. And then it requires usually bringing in other parties that have been involved in the situation with the supportive adults in the room to move through a discussion, to share their thoughts, express their condolences and what actions they're going to take next to remedy the situation, heal the situation, depending on what the situation is, and give the other members of the party an opportunity to speak to that individual as well.
I think that just a warning to begin with before even restorative justice. Just, I don't think that process seems to be very convoluted. The person who was called the name may not really want to hear an apology, just don't do it anymore. Okay, and that just a little warning saying, look, if it happens again, then we have to go through this process.
I still don't think that this is a list in order of the way that remedies are.
Then just list it
Given.
as a remedy.
And I was gonna say, if it means just adding it as an example of an option of a remedy, we don't get to decide what remedy is given. So if it means including it as an option, I agree. I think it's part of restorative justice. It is included for adults, employees, I should say. So
And I'm just wondering there, I'm actually not, I'm not loving that, right there. But it may be part of, collective bargaining, and that's what I'm not sure where that.
and I don't know if legally we can only issue a written warning in response to a phone call.
Yeah. The determination,
students.
yeah.
I don't know. So maybe we table this one and keep going.
Okay.
That's a good question.
The only other thing that I was wondering is if we could get maybe twice yearly, just sort of a statistical report of the number of complaints filed based on various criteria and just.
What would we do with that?
I think we need to figure out if we have a problem that needs to be addressed in a bigger way.
Are you talking about policy or the school board?
To the
policy committee?
like a policy that, well, actually, for the school board, I think somewhere in the policy would be on a bi-yearly basis, we would get a report of incidents and basic information just in terms of what kind of incident it is and what kind of determination there was and
I hear what you're saying, right, to see how policies are working and that kind of thing.
right.
One of the things I want to be careful of is overextending what our role is here versus our job is to, our one job is to hire, or one employee is to hire the superintendent who then hires highly qualified individuals to implement the policies. I hear what you're saying. How do we know that those are working? And I think that'll be something to, I could see bringing that forward, but then what we would do with it, you know, how do we tweak policy maybe at that point? But I think we would be getting notice from administrators, hey, this is inadequate for our practice.
So Joanne, we do collect that data.
Oh, thank you.
We do report data, and it's for lots of things. Bullying, restraint and seclusion procedures, any sort of major procedural incident. We do collect that data. It is anonymized and reported to the state. And then that's aggregated to look sort of at trends across the state. We look at that as an administrative team. Once in a while, we have been asked to prepare like a state of the schools address to the board. And oftentimes when we do that, we include data that lets you know how we're doing in terms of those numbers. It is anonymized. You will not know the incidents of the students, but
Of course.
we're able to indicate some of the major infractions, how many, in a period of time. That's already done and can be requested when we do like those sorts of presentations to the full board usually.
I would say, I personally,
I hear you. I just want to
Yeah.
keep moving on the
This is-
policies we
we
have
need to
before
focus
us.
on, yeah.
If that's all right. So I think we're going to table this one. We're going to come back. I guess we need to check either with Pat or potentially council to determine
For H number 2,
Adding
written warning.
yes.
Okay. Okay,
And or removing it from item 3 as well.
okay.
H2 and 3. Yeah. All right. Yeah, so tabled there, moving on to ACAB, policy ACAB.
The chance spelling.
Spelling of locks, yeah. So this defines harassment, sexual harassment of school employees. So in the workplace. Out of those same definitions.
So okay.
Yeah.
Don't want to go back too far, but that in that section H, I'm just curious, is it because it's the sexual harassment policy that we don't call it the AAO Title IX coordinator in H1? Because it seems to be consistently AAO Title IX coordinator throughout the rest.
/ Title IX.
So page 12. And I know AAO wouldn't it be? Yeah,
Just same person in our district. I'm sure if you want it added, we can fix it.
right.
ACAB.
CAB, yeah, so. Harassment and sexual harassment of school employees.
Any notes?
Uh, Actually, I think I'm good on that one. Same definition, same. Concepts, and then, so if we can move on to ACAB-R, which is the employee discrimination and harassment and Title IX sexual harassment complaint procedures. Identifies or affirmative action officer and Title IX coordinator, definitions.
Why do we have the employee one in the student one?
Oh. What do you What do you mean?
So when you go to page 12 of ACAA-R, it's discipline of employees, but this is the student policy. And when you go to,
Oh,
when you go to page 11 of ACAB-R of the employee policy, we have the discipline actions for employees, but not students. So why would we have the employee section under the student policy? Is it because employees might be involved? If they're involved, when they're under the next policy?
I think
Good question.
my understanding from that one, from ACAA-R, that reading was if an employee is found to have sexually harassed a student, that would be.
To make sure that they're not missed when going through the student policy violations.
Yes, I
Okay.
think so.
Thank you.
Yeah. It's a.
They parallel and
Yeah,
same.
But, you know, it
measures.
doesn't, you know, it doesn't specify that in that one. That's another
Yeah.
thing to come back to on ACAA-R.
I'll make a note just to make sure.
So this is the, so back to ACAB-R.
Anything else?
I think it just kind of comes down to the same question. I don't know if that means we table both just to revisit that.
So this is the one that has the written. I did add a off.
Those kinds of.
Quick formatting note on page 10 of 13 in ACAB-R. Let's see, I6, so just above G, termination of responsibility, the paragraph there just says 40 business days with a closed bracket. But are we, so did I hear a kind of an idea that we might table this one?
Yeah, I think
As well,
especially
same.
if we add or remove if we remove the written from ACAA-R, we would need to remove it from here as well.
Only if allowed.
Only if allowed, exactly. I'm just saying we're tabling that one, I think for the same reason we need to table this.
Yep.
Until we have an answer. Each.
What number is that? That is
ACAB-R.
H2, right?
Yeah, for written warning.
And there's only other piece on page 13, the very last two words. In the other, it's 7 with the 7 in parentheses, and that's gonna left it out. It's just consistent.
Okay.
Yep. Nice. All right, then, great. So those are the walk back ones. Then these are the up for regular review, I think, the next ones. So the first one is JCD, limited open enrollment for elementary schools. And this allows parents to request request, but not guaranteed to access another school in the district.
I just noticed in the fifth bullet point, the second line, open enrollment, there's some kind of little spacing thing.
Oh, yeah, wow. It's not just on my screen.
No.
And then the application is part of actually,
It's a separate one. It's JCD, but the form, it shows up separately because it's a separate form so that parents can just
Yeah.
download the form.
do we usually like mark it somehow as like a -R or?
It's confusing to me because when you see the bottom, it says, see the school board policy JCD. But if they were stuck just looking at this form because it's
I can look at how it's posted.
well, in our list, it's posted as JCD, but
Yeah, but I can see how like parents access it.
Yeah. I do like the hot link in there.
can you see that?
So it's JCD open enrollment, and the PDF below it is JCD limited open enrollment request form. How it's posted currently.
Okay.
And I can look at the table of contents. It's written the same way in the table of contents. I know it might be different in other ones. I can't speak to that.
Yeah. Can we change that to
Just like-
label it?
JCDA or something,
dash?
JCD form.
Request some sort of signifier.
Yep.
Yes, perfect. All right. And I thought that looked good. It has a little reason for doing it, but it's brief and to the point, and superintendent has final decision. All right, moving on. Policy JFD, pre-kindergarten enrollment.
Change indicated on this one was just the class size at Helen Thompson, following class size policy. They all pre-K classrooms have the same class size maximum.
So 16, yeah.
At all schools.
Can I just ask, so in item 2, it gives an exception. And then in the next paragraph, it gives another exception. I think that one can be a little confusing.
Oh, and at the top there,
Yeah.
for eligible students, yeah, number 2, then there's an exception, and then there's
And then
another
there's the
exception.
asterisk exception that describes it a little differently. I just don't know if we can label it differently or.
Yeah.
We could put both exceptions, one after another,
Yeah.
do number 1, number 2, and then hold that exception down and have it read just like the first one.
Yeah.
If you want.
That's either 3 and 4 there, or
Or exceptions to the October 15th
Yep.
date in bold, and
Yeah.
then 1, and then separate by a paragraph and 2.
yes.
Okay.
I think it actually read a little bit confusing because there's 2 sets of dates, right? September 1 to October 15, and then July 1 to October 15th, yeah.
Okay. And in other eligible students, there's another asterisk,
And it goes to the note.
but there, it's on 2 and 3. I don't know. I understand, but I just don't know if it's. Is there,
Yeah, because it applies to both.
Yeah.
Same rationale that applies to.
Should we use like a double asterisk or anything? So it's not.
It's the same rationale to.
I know, but we used an asterisk above with the exceptions, and then down
Sure.
here, we're using a new asterisk.
We can do that.
And
So they don't go above, they go to the double below.
Right.
You good with that, Tony?
Well, they missed the one above where it says exception and they dropped to that note. We just need to differentiate.
Twice, asterisk twice, asterisk twice.
Yeah,
And then up
so
here
it's-
you have one asterisk and this
it
one
would go to that
asterisk.
one, yeah. So that's the one asterisk exception here, and then a double asterisk exception.
To the notes.
Yeah, I like that. The only other thing I would change there
Yeah,
is,
because say Sean, you might.
Yeah.
We got
Yeah,
another
but we're
meeting.
still in a board meeting.
Thanks.
the only other thing I would change there is, can we put the maybe charge tuition on number 3 inside the double asterisk?
Oh,
that we're
sure,
proposing?
yeah.
Because those are two separate things, right?
Yeah.
The
So
tuition.
put the asterisks on the outside of those.
Yes,
Okay.
yes, please. Yeah. All right.
Okay.
How we doing?
We have 4 minutes.
Yeah,
Okay, let's move then.
all right, we got, so if nothing further on JFP, we'll move to
Yeah.
policy JJ, IF, management of
Excuse
concussion.
me, the audience, it's really hard. We're trying to finish the last couple policies. If you can just hang out for 4 minutes, just really quietly, it would be really helpful for us to get through the last bit. I appreciate it.
Thank you.
Which one are we on? JJIF?
JJIF, management of concussion and other head injuries.
Okay,
So we had just some adjustments there, identifying the concussion management team, building an administrator. Instead of head of school.
right.
Yeah.
And then there's just some language changes.
Yeah. To identify, connection of students.
Yeah.
To guardians.
I didn't have anything else.
And it does, it says they can't drive away from concussion event. Don't let them drive away. Yeah. Data point. Okay. And let's see, it just looked to me at the bottom of that, there's a formatting thing, there's like a 5th page that just has the resource guide listed. I don't know if it can be moved up. I don't know if it can just stay there. It's floating.
It's strange to me to have the review dates and everything before that.
Yeah. Usually that's the last, isn't it?
My guess is this is part of this last page was part of the sample policy. And it helped the readers in reviewing the sample policy, make sure that they understood the rationale for components in the policy, and sometimes that's removed before being approved. Page 5 in this case.
Okay. So it would change to 4-page policy.
Yeah, it would change to a 4-page policy. Unless you wanted to keep that in there, you already have the chaptered law referenced under legal reference.
We can, if we can take it out, I'd say do that, yeah. All right, we were at 6:29, we had 2 policies left. But I think we're gonna end up tabling those.
Okay.
Is that all right? So those 2 policies, so we've got ACAA-R and ACAB-R tabled, and then ACA-R and JL on tabled. So let's see, can I get a motion to advance the other ones for first reading to the board?
Second.
All right, any further discussion? Yeah, all in favor? So to clarify, it's other than the tabled ones, we're moving those first. Those policies forward for the first reading.
Yeah.
Okay. Great, meeting adjourned for policy.